Tuelekee tena katika shoroba za mahakama ambapo tutakuwa tunarudi kwake Stella Mutuku ili tuweze kujua ni hatma ipi ambayo Wairimu Cohen anayo.
When I take into account the length of time it has taken for the DCI to collect and preserve evidence and the fact that they guard what they believe is a crime scene, I can only state that this ground has not been proved. Further, for ends of justice to be met and to protect the rights of all the parties, this court has the powers and discretion to put in place conditions that will ensure any pending investigations at the scene of crime are not interfered with. On the issue of public disturbance and trivializing the trial, I find no evidence to support this allegation. Inspector Otieno, in paragraph 16 of the replying affidavit, refers to unnamed persons as the source of information that the accused and her counsel caused the disturbance at the burial of the deceased. This is not evidence, and Inspector Otieno knows better. Further, it has, especially when the source of that information is not disclosed. Further, it has not been demonstrated that the accused is in a position to cause public disturbance, undermine public peace, or cause public insecurity. Bail or bond is a right that is available to all accused persons irrespective of the offense. I'm also of the view that other accused persons facing murder charges have been released on bail or bond, and their release did not in any manner trivialize the seriousness of the offense of murder. Finally, on the issue of the accused breaching a court order by addressing the public during the burial of the deceased, it is my view that this matter will be subject to anticipated application for contempt of court, and it is prudent to decline discussing it in this application. The Court of Appeal in Michael Ojuma Oyamo and another, which was cited by the defense, adopted the definition of the High Court in Jackton Malende and three others as follows, and I quote, "The phrase compelling reasons would denote reasons that are forceful and convincing as to make the court feel strongly that the accused should not be released on bond. Bail should not therefore be denied on flimsy grounds but on real and cogent grounds that meet the high standards set by the Constitution." End of the quote. In overturning the decision of the High Court in declining to grant bail to accused persons in the same case cited above, the Court of Appeal stated as follows, and I quote, "We must state that evidence as contained in the witness statements before it has been subjected to cross-examination and careful analysis thereafter bears very little weight, unless where an accused person has expressly and voluntarily admitted the contents of the witness statement." End of the quote. This was in reference to the argument that the case against the accused is serious and the evidence is strong. I must point out here that unlike in the case under reference, in this case, the defense does not even have the benefit of witness statements. Despite this, the prosecution and the victim submitted that the case against her is a serious one, attracting death sentence once proved, and further that the evidence is strong. My view is that the same principle advanced by the Court of Appeal in the case I've cited also applies in this case. I wish to state that I have also considered the authorities cited by the victim. This is Republic versus Kunguru Martin Opio and Republic versus Zakaria Okoth Ombado. I have distinguished the two cases with the case before me in that the circumstances were different and the courts in those cases had the